Hello, legal scholars. Welcome to this episode of Nigerian Law Simplified. My name is Chukwubike Monumajero, and I'm your facilitator on this amazing learning journey. Today, we are beginning our contract law series where we will discuss various topics under contract law. Contract law as an LLB course in the university is quite wide and bulky with so many case laws. It is also very technical due to the many general rules, exceptions, and even exceptions to exceptions throughout the course. So it is no wonder that a lot of students see contract law as so big and mighty. But don't be afraid. There is no such thing as a big thing. Every big thing you see is just a combination of small things. And in this series, we are going to tackle this course systematically. In today's lesson, I'm going to do three things. First, I'm going to outline the structure and scope of this series so that you know what to expect throughout the series. Second, I'll be doing a general introduction of contract law in which we will consider the what, why, and how of contract law. And lastly, I'll be defining some key terms which are vital to understanding contract law. So, let's begin. This series will be divided into 4 parts, which cover the general scope of the contract law course that is usually spread across 2 semesters. Part 1 has to do with the formation of a contract, which entails the definition of a contract, the elements of a contract, and the vitiating factors which can invalidate a contract. Part 2 concerns the contents of a contract, which include express terms, implied terms, conditions, warranties, and the like. Part 3 deals with the termination of a contract, either through performance, agreement, frustration, or breach. Part 4 then deals with the remedies in the event of a breach of contract. These 4 parts form what I call the flow of contract law. Any issue you will encounter in contract law will cut across one or more of these 4 parts. So how does this flow work? The flow starts from the point of contract formation. And the question to ask at this point is, has a contract been formed between the parties? If no, then contractual obligations are not created at all between the parties. But if yes, then contractual obligations are created according to the agreed terms, which are the contents of the contract. Where contractual obligations exist, then there must be a performance of the contractual obligation. Another important question to ask at this point is, what happens where there is non-performance of the contractual obligations? That brings us to the remedies for the non-performance of the contractual obligations, especially where there is no reasonable excuse for such non-performance. These 4 parts mark the outline of our contract law series. Let us then proceed to the general overview. I believe that no matter how complex or sophisticated any concept is, you can make it easy to understand by breaking it down to basic ideas. So before you can say that you truly know a thing, you must know what that thing is, why it exists, and how it operates. So today, we want to look at the what, why, and how of contract law. What is contract law? Contract law refers to the totality of the rules, legal principles, and authorities that are applicable to contracts. Contract law is simply the collection of legal authorities which regulate contracts. Such legal authorities include statutes, case law, Latin legal maxims, and legal principles that apply to contracts. So basically, any legal authority that regulates contract forms part of the body of what is referred to as contract law. Why does contract law exist? Contract law serves as a means of ensuring that parties to a contract fulfill the promises which they made under the said contract, or face the consequences for the failure to fulfill their promises. Think about it. If persons are allowed to break their contractual promises without any consequences, it would drastically affect the economy of the society, as there would be no trusted system of doing business in such society. The confidence with which we enter into several contracts on a daily basis is derived from our knowledge of the fact that there are laws governing those contracts, and that failure to comply with the terms of the contract will have repercussions. Without contract law, our commercial sector will fall into disorder and chaos and thus sink the economy. So, how does contract law work? Contract law operates by acting as the legal framework for a court to act as an umpire between the parties to the contract in order to ensure that the parties fulfill the terms of the contract which they entered into, and also to ensure that both parties play by the rules and principles of contract law throughout all stages of the contract. What this means is that the court will only act as a referee, ensuring that the parties to the contract are complying with the rules of contract. Wherever there is any foul play by any of the parties, the courts can flag that and remedy the issue. Now to the key terms. In the realm of contract law, there are certain recurrent key terms which we need to be familiar with in order to aid our understanding as we progress in this course. Throughout this series, we will keep making reference to these key terms, so it is important that you understand them. I will go through a few of these key terms now. First, agreement. An agreement occurs where one person makes a promise to another person, stating that he will do or not do a particular thing. Once a promise has been made and the other party accepts the promise, an agreement occurs, and an obligation is placed on each party to the agreement to act in a manner that is in accordance with the agreement. What this entails is that if I promise to cook food for you and you accept my promise, then an agreement has ensued that I will cook food for you. It's that simple. Once someone makes a statement to another person indicating his intention to do or not do a particular thing for that other person, then that person has made a promise. And if the person to whom the promise is directed accepts, then an agreement has occurred. So, since we have an agreement that I will cook for you, I am expected to act in line with that agreement and go ahead to cook for you. Now, for an agreement to be said to have properly occurred, it is important that the parties to the agreement have a clear understanding of the particular thing which they are promising to do or not to do. This clear understanding is referred to as consensus ad idem, which means the meeting of the minds of the parties. If there is no such understanding, an agreement cannot be said to have occurred. So if I promised to cook for you, but you thought I was saying I was going to wash your clothes for you, then there is no clear understanding, and as such, there is no consensus ad idem, which means there is no agreement. The parties must be clear on what they are agreeing to do or not to do. The next key term is the term binding, and this refers to something that has legal force and must be followed or adhered to by the persons involved. In legal parlance, binding means that a thing is enforceable by law. So the law will go ahead and enforce the thing because it is deemed binding. A quick example of that is our criminal code. The provisions of the criminal code are binding because the law will enforce those provisions. So in legal parlance, a thing is deemed binding if it is enforceable by law. The next key term is duties or obligations. In an agreement, the parties promise each other that they will perform certain actions or omissions. That is, they will do some things or that they will not do some things. Now, these actions and omissions, which the parties promise to perform or not to perform, are called contractual duties or obligations. So those things that the parties have promised to say, I will not do this or I will do this, that thing becomes a duty on them. So just like our earlier example, if I said I will cook for you and then you said you will give me the sum of 10,000 naira in exchange for cooking for you, my promise to cook for you has become a contractual obligation on me, and your promise to give me the sum of 10,000 naira in exchange for cooking for you has become a contractual obligation on you. So, duties and obligations arise in contracts based on the promises made by both parties to each other. That brings us to the end of today's lesson. If you have any questions, please feel free to ask them in the comments. Thank you so much for taking your time to watch this video. I hope you've learned something valuable here today. Please make sure you like this video, leave a comment, and share this video with your colleagues so that they can learn alongside you. Don't forget to subscribe and put on the notifications. Thank you once again. I will see you in the next lesson.